Well, good morning, everyone. Thanks for being with us. Welcome to the Dental Board of California special meeting. Today is Friday, October 5, 2018. I would like to ask all of us to please turn our cell phones to silent and make sure they're off the table so we can avoid feedback noise. You may notice board members accessing their laptops during the meeting. They are using the laptop solely to access the board meeting materials that are in electronic format. This is an official business meeting of the Dental Board of California. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to the board taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak on that item, please raise your hand and you will be recognized. Depending on the number of people who would like to testify on a particular agenda item, a time limit may be imposed. We will ask all speakers to please stay on topic, and if a time limit is determined to be necessary, keep your comments to within that time limit. I would like to now call the meeting to order and ask the board secretary to please call the roll.
Yes, Mr. President. Burton. Here. Jan. Chappelle Ingram here. Lai.
Here.
Laren.
Here.
Lay.
Here.
Mackenzie.
Here.
Morrow.
Here.
Allegui. Pacheco. Stewart.
Here.
Richard. You.
Here.
Mr. President, we have a forum.
Thank you. I'm going to take two items out of order to hopefully accommodate potential public members. And so item number 3 will now be before us, public comments on items not on the agenda. Seeing none, let's move to item number 4, board member comments on items not on the agenda. Seeing none, then we will be back to discussion and possible action to approve the board sunset review report for submission to the legislature by December 1st, 2018. Karen?
Good morning. Karen Fisher, Executive Officer of the Dental Board. I like this perspective because now I can see everybody's faces from down here and I can tell whether you're taking a little snooze. I may have to look into this in the future, just coming from a different perspective. I'd just like to make a few introductions before we start. We have hired 2 legislative and regulatory analysts, and they're in the audience today, David McLean and Michael Chen. They'll be working with us closely to learn the legislative process and the regulatory process, and we have high hopes that they're going to be working out well. So, gentlemen, if you'd like to stand up and just say hi. Well, I guess there is an advantage. I don't have eyes in the back of my head, so we do have a problem here. Also wanted to make a recommendation. When I listened to the board meeting on our webcast, oftentimes when you vote, you don't use your microphones. So I'm going to ask Secretary Chappelle Ingram, when you call the vote now, call the last name, and when they say what their response is, if you'll repeat their last name and say what their response is. For an example, Dr. Stewart says aye, Stewart aye. All right? That way, I always hear you, but oftentimes we don't hear who's voting, and I think that that's important for the public to know who's voting. Okay, with that being said, for those of you that didn't get to meet our investigator that's in the room with us today, it's Kelly Silva. And if you haven't had a chance to meet her personally, please, when we have a break or at lunch, go and introduce yourself. It's good that you get to know our investigators who are out in the field investigating these cases. So what we're going to do today is move forward, starting to again discuss the report. Now, the report has been, your comments were incorporated from the August meeting. Hopefully you noticed that we pared it down about 10 or 12 pages. We got right to the point. I wanted to also explain the perspective because there was a lot of discussion about whether or not we gave enough background information on certain questions. The questions are coming from staff at the legislature, so they already have a lot of the background, so it's not critical that we spend a lot of time discussing that. So a lot of the questions we cut right to the chase. So I anticipate that we'll go through section by section, make sure everybody understands what we're saying, give you the opportunity to ask any additional questions. What will happen after today, whatever changes we will be incorporating, we'll do that right away, and then we send this off to the DCA Publications Department. They are going to format it, they're going to make it look pretty, and then we'll be able to distribute it to the legislature in time for the December 1st deadline. Are there any questions about the process? Okay, we're expecting that lunch is going to be delivered around 11:30. At that time, around noon, we'll be taking the break for lunch. We'll ask all board members to follow us actually into our suite, and the lunches will be served there in our conference room. And we will see how the discussion on the report goes prior to lunch, and that will determine how much time we actually have for a lunch period before we need to come back. We are anticipating you're going to have a somewhat brief closed session, and we're anticipating also that we need to make sure that we adjourn the meeting by 3 o'clock in order to get people to the airport to catch their flights. I don't anticipate we're going to have a problem with that, but there may be times during discussions where we just give you sort of a time reminder of where we are and whether or not we need to move on. Again, are there any questions? Awesome, then we can get started. Does everybody, if anybody needed to access the internet, Cesar is here. I'm sorry, Cesar, I didn't introduce you, but I saw that you were actually approaching the board members. So Cesar is our new Lou, and I'm happy to report Lou is off enjoying his retirement. And for those that didn't know this, there is a hearing room at the headquarters, and it was actually named after Lou. And it was quite an honor for him to have that room named after him. And you all can feel a part of that too, because he felt very, very close to our board members and to the dental board. Send us a lovely note saying, that he appreciated being honored at our last meeting. And so we'll look forward to hopefully having Cesar with us on a regular basis. They are a little short with webcasters, so we're welcome you into the family, Cesar. So if anybody has any questions about Wi-Fi hookups or whatever, Cesar, raise your hand and Cesar can come over and assist you. At that, we'll get started. We're going to be looking at Section 1. There were not a lot of comments or questions in Section 1. This is the background and description of the board and regulated process. So Section 1. Does anybody have anything particularly highlighted in Section 1 that they needed to discuss?
It's just a matter of, I'm looking at this as if the legislators were looking at it.
Well, and just to, again, look at this as if the staff at the legislature is going to be looking at this, because they are actually going to be turning around writing the background report based on our background report.
Okay.
So this is going to be going, another introduction that I didn't make. I apologize, Robbie. Where's Robbie? Okay. So Robert Sumner is the consultant that we are going to be working with in the Assembly Business and Professions Committee. So he's been assigned to the dental board. I anticipate that we'll be working closely. He will be working closely with staff to get any additional comments on some of the information we've put into this report. So Robbie, did you stand up? Okay. So welcome. Welcome. Okay. Thank you, Sarah. I just got Sarah's text that I didn't introduce Robbie.
Now we know how you communicate.
This is, it's a little different today, having everybody come in on the same day and for us, so bear with us. So at that, Yvette, you're my go-to editor.
No.
What was your comment going to be?
It's not, it's not big, but under anesthesia committee.
If you'll tell me, identify
I'm sorry,
what
page 4.
Okay.
Under anesthesia committee.
Uh-huh.
And, the first line where it says the anesthesia committee is composed of 5 members. And I have of the board. Is that, will that be of importance, or is it just minor?
Well, I think at the beginning of that section, we talk about that the members are board members. So at where on page 2, where we start to talk about the committees,
Yes.
we do say essentially that all of our committees, absent the statutory ones, the dental assisting committee, the elective facial cosmetic, the diversion committee, all the additional committees are board members.
Okay.
Does that answer your question?
It does.
Okay.
I just didn't want them asking you that question.
Okay. Are there any other comments in section 1? And again, I want to emphasize that please review your individual attendance record to make sure that it lines up with yours. We have added today's meeting, and so after the meeting, we will be making that change to update it.
Noticed on that for Deborah Wu that you didn't have a separation date.
Okay. What page is that?
'23.
Thank you.
I could notice everybody else's but mine. Is this true for Dr. Yu on page 24? I thought I remember, maybe I'm wrong, but I thought I remembered seeing him in San Francisco. Okay, then it's blank. Gotta check it out.
Thank you so much.
That's why she's the secretary. Any others? Okay, then after we get through all of the attendance records, it brings us to page 49. You'll notice that we did change up the internal changes significantly. We used bullets. We did lead off with some of the bullets that board members had indicated they felt were critical and to lead off with. Does anybody have any questions or comments about the internal changes? And if some of the things don't seem as if they should be here, there really was not another place in the report to put it, so we thought it was important enough to at least mention it. Okay, we'll move on to the legislation sponsored by the board. Typically, the board doesn't sponsor a lot of legislation, and during sunset review is a period of time where the board really does have an opportunity to get a lot of things into the sunset legislation. So the legislation that was sponsored essentially within the last period of time was the change to the RDA practical examination. And so that was necessary, and we were we were grateful that it went through, and everything else that's listed in the legislative sections you have seen before, because at the end of the 2 years legislative cycle, we put out a legislative update and let you know essentially legislation that we've been following and that does affect the board appears. And so now what we've done is we've gathered all that information and put it into this report. So unless there's any questions specifically about legislation. Same thing with our regulations. We have outlined essentially the regulations that have been approved by the board. Now, for the benefit of the new members, if you have any questions about some of these regulations, please feel free to contact me after the meeting. I'll be happy to walk through some of these things with you so that you have a clearer understanding. Next year probably will be a very busy year for our regulatory process. It's a little difficult to grasp unless you've gone through it. And so just giving you a heads up, you will be going through it next year. We'll be moving things along. So this is a pretty comprehensive list of essentially everything we've accomplished in the last 4 years. And as Dr. Witcher mentioned to me before the board meeting, wow, we've gotten through a lot in the last 4 years.
Karen?
Yes.
I have a question on page 59.
Mm-hmm.
Dental Board of California Pediatric Anesthesia Study.
Mm-hmm.
The last sentence, board to review all incident reports collected by the board. Was that all incident reports or just the 1080Z? I mean, all incident reports related to anesthesia, but I'm just wondering if Senator Hill's request was all incident reports or just the deaths?
Just related to death.
Okay. Well, but here
Yeah,
it says
pediatric
all
deaths.
incident reports, so I was just wondering if that's reflecting specifically what Senator Hill requested.
Okay, I'll make a note to clarify. Okay, thank you. Any additional comments?
I have a question on page 51, AB 1174. The first sentence, the second sentence prohibits a dentist from supervising a specific number of dental auxiliaries. Is that correct? Prohibits a dentist? I don't understand
Is this
that part.
related to EFs?
Sarah Wallace, Assistant Executive Officer. There is a provision currently in the Business and Professions Code that prohibits the supervision of more than 3 RDA-EFs or 3 RDHs. And I believe that this had a prohibition included in it relating to AB 1174. That's the teledentistry model where they were able to go out. So they did have a specified number of RDA-EFs that could be supervised.
So should it be open like that, or should it be more defined in that?
Typically in our bill summaries, we just keep it brief and general.
All right, thanks.
Thank you, Dr. Lai. Any other comments in this section? So we're looking at any comments you might have on legislation or regulations.
On page 64, bottom of the page, is the board using a national exam? How is the board involved in development and so forth? At present, the board does not use a national clinical exam. Are we confining that to clinical exams only, because we do utilize the national exam in the written national board exam, which is a national exam, but it is not a
Right.
clinical exam, it's a written exam.
Right, and I believe we cover that in the licensing section where we mentioned part of licensure does require taking the national examination.
I have a question
Mhm.
or an observation, page 64. And it is how many meetings did the board representatives attend? But it asks when and where. Did we answer that question? It says where. I don't think we did.
Okay.
Or when. Well, it says some, but it doesn't have it in others. So we might want to take a look at that.
All right. I wanted to draw your attention to the discussion about the voting privileges, and that was in question 5 on page 62. In terms of the board's attendance at the American Association of Dental Boards, I know that there was a robust discussion about whether or not we could attend this. That's a discussion for another time in terms of discussing whether the travel restrictions from the governor's office will be lifted. So it's something that we will be looking to the incoming administration to determine whether we'll have more flexibility to be able to travel out of state to attend these things. So what was clarified was that if we did have a board representative able to attend in an official capacity, we would have voting rights. Okay, so we do pay dues to this organization. We are a member of this organization, but due to our travel restrictions, we have not been able to participate. We have not been able to send a representative to participate in a voting way. Fortunately, we have had board members who have either attended on behalf of themselves or on behalf of, say, a school that they represented. So we do have the we are able to get the information of what goes on at those meetings. So that part was clarified based on comments taken at the August meeting.
Just a point of clarification on that.
Mhm.
If a member of the dental board attended an American Association of Dental Boards meeting,
Mhm.
but paid their own expenses to travel there, would they be considered, or could they be considered an official representative from the dental board?
I don't believe so. And it has to do with our travel restrictions.
So the travel restrictions are not monetary. In other words,
No.
if because I'm a member of that association,
Right.
if I traveled there at my own expense, I could not represent the board.
That's correct.
Only myself
That's
or
correct.
my institution. Okay,
Yes.
thanks.
Yeah. And some of these things we'll be discussing further in next year. We can agendize and have further discussions about what the board can and cannot do. But typically for out of state, regardless of who's paying, we still have to get a special exemption or approval from the administration in order to participate. It is a little bit cumbersome.
How much are the dues?
I will have to check on that. Any additional questions? If there are no additional questions, we're going to move into section 2, which performance measures and customer satisfaction surveys. We didn't have a lot of comments on this at the August meeting, so there weren't a lot of changes made here. The primarily what this is showing essentially is the customer satisfaction survey that goes out, and so we've recorded the responses that we have received. We've talked about this before in terms of a customer satisfaction survey. Some people think that a low response rate means people are satisfied. Others think that they're not. And we wouldn't really know. So it is what it is, and we always try to do better in what we do in delivering information to the consumer and public protection. So keeping that in mind, we always are looking at these numbers and ways to improve it. Are there any questions about this section? Okay, so we're moving into section 3 now, which is the fiscal and staff. Jerry has a page that she's going to be passing out, and there are additional copies at the back of the room. This has to do with question number 10, which was modified. In your copy, it said the last sentence on the page was highlighted and said that this section will be updated if 501 is signed. And so we know 501 was signed last Saturday by the governor. We also know that it carries with it a huge money obligation, and we are now in the process of determining exactly what that's going to be. So Jerry's passing out essentially the changes that were made. So if you'll look at what she's passing out, and so 10, the question says, describe if and when a deficit is projected to occur and if and when fee increase or reduction is anticipated. Describe the fee changes, increases or decreases anticipated by the board. So the first paragraph somewhat remains the same. It's the second paragraph that we added. So it should be noted that the board will incur a significant fiscal impact due to recently enacted legislation. The board's dentistry fund cannot currently support the expenditures needed to implement the provisions of this legislation, and the board anticipates a structural imbalance between its revenues and expenditures beginning in fiscal year 22-23. The board is working with the DCA Budget Office to develop a plan to address the anticipated structural imbalance. So basically what we're saying, because we don't know what the specifics will be, and we have time to figure that out, we just want to make sure that the legislature is aware that in particular 501 is a big ticket item. Now, this would hold the same for any piece of legislation that the board would need to implement in the future. So the board needs to constantly observe where our fund is and adjust appropriately with fee increases. We brought this up at the meeting in August that 501 was a big ticket item. So associations and stakeholders are aware that there'll likely be a fee increase coming from this. And so stay tuned. We'll be talking about this in the future as we start to talk about what the implementation plan is going to be for SB 501 and moving forward. Does anybody have any questions specifically about how we inserted this paragraph into this section? Do you have any concerns? Thank you. Okay, so we're continuing in section 3. I want to let you know that staff is constantly reviewing these tables that we've put in just to verify that we've got the numbers correct. So on page 72 on the fund condition, the last two columns, so fiscal year 18-19 on table 2A, rather than 7 months in reserve should be 6.8. And in 2019-20, the months in reserve dropped down to 6.6. By 22-23, you'll see in future board meetings, we drop way down. So we'll be discussing that more at future board meetings. Does anybody have any additional questions about section 3?
Yes. On page 76,
Mm-hmm.
where we discuss breeze,
Mm-hmm.
number 13, and the cost. One of the problems that I have with charts like this is that they don't show a full picture. Because it was such a big issue for us, is it possible to show an estimated cost as well as an actual breeze cost? Because that's one of the things that led us down the road into running into a deficiency.
Right.
So do we still have the estimated cost?
You mean going backwards? What we were told it was going to cost initially and what
Right.
it ended up costing? Are you talking about the overall cost of saying Breeze initially was going to be, the total implementation for the department was going to be something like 97 million and it tripled? Is that what you mean? Or are you?
Either. But specific to us. Our estimated cost at first was significantly lower than what we finally ended up paying.
And it's up to the board to determine whether how you want to move forward with still addressing this. The question says, describe the amount the board has contributed to the Breeze program and what are the anticipated Breeze costs the board has received from DCA. This is moving forward. Do you think it's important to look back? From what I understand, I think it's well known at the legislature that the costs well exceeded what was anticipated. I think that what we're showing here in this report is that we recognized that and we dealt with it, and that we'll continue to deal with these issues as they come up and adjust our fund appropriately.
But is it in fact well known per board?
I can't answer that. I think it's well known for the dental board, but I can't answer whether the legislative staff, and I would assume that they're well aware of essentially the impact that Breeze had on all the boards. So where were you anticipating that a comment would be made, Ms. Burton?
I think that you could either make an overall comment in the narrative, or particularly in the early years where the estimated cost was so much higher than the actual cost, if it could be reflected there.
I think
And maybe before you do that, if you, maybe that's a side question that you ask to legislative staff, whether that information would be helpful.
Okay. Sarah, did you have a comment? Okay.
So
We'll make a note of that.
Okay.
sorry, I have one question, slightly going backwards. So obviously, so we just added the paragraph about SB 501. We don't mention that in legislation affecting the board since the last sunset review. Should that be added in that section? Because we're saying it's affecting us, at least fiscally.
I think, well, and Sarah, you might want to come up and approach this too. I think we drew the line for, conceivably we could be updating this report until the very last minute. And so I think that it was important to at least recognize the fiscal impact going into the future based on 501. Should we put the recently signed legislation into the report?
In past sunset review reports, we typically report up to the year prior to the report being submitted in terms of legislation. So we can clarify with legislative staff to see what they would prefer.
As long as it's clear what we're reporting, because it does seem a little odd that we're saying that we don't mention it, yet we're mentioning later, of course,
Right.
it has the fiscal impact. So that's the only reason I
Right.
noticed.
And typically our cutoff would have been June 30th of this year for
Yeah.
reporting 17-18.
Which would make sense. Yeah.
And so we'll check with Robbie. We'll check with Robbie. We're not going to put him on the spot right now, but we'll make a note and we'll check with Robbie about what he thinks.
Seven, where the whole discussion about fees and how fees have changed. because I am a visual person, I think a better visual here, if we could do it, would be a pie chart. And that's, I'm just going to put that out there as my preference. And maybe we can have some discussion about that.
Did you want to clarify what you mean? What did you think the pie chart would reflect?
Well, the question, what led to this was our revenue versus our expenses. And so what does that look like? What kinds of things, what kinds of expenses did we have?
Fran, what section are you talking about?
Page 77,
Question 14.
number 14.
Okay, so it's talking about renewal cycles.
Yes, and the big issue for us was that we had the same fee for 16 years. And then suddenly we had a fee increase, and shortly after the fee increase, then we had to raise the cap. And I don't always assume that people who were here yesterday are the same people who are here today. And to give it to people in a way that they understand how this happened outside of our control. And so what you have here is a bunch of numbers. The number was this, and then the number went to that. But then, we had expenses. And so why not show that? Why not show what that looks like in a pie chart?
I mean, I understand everything you said up until the pie chart. I can't figure out what a pie chart would be of. Usually a pie chart is if you have a bunch of things and you're classifying them into different categories.
That's exactly what I'm suggesting. We know how much we pay for Embreeze costs, for instance. We know how much.
But that's not what it's asking. It's asking about the license renewal cycles and history of fee changes.
But it's the justification for the fee changes that I am hoping to show.
Okay.
What's the will of the board?
I'm more of a visual person as well, because sometimes the numbers get lost in paragraphs when you go from one paragraph to another. So if you can have something that's really comprehensive in a sense, and maybe a bar chart or a pie chart, it makes a lot of sense when we can see you can still leave the sentences in, but if you did have that chart, it's comprehensive. And you could really see the difference, if that's possible.
If I could just comment here, when we're looking at the history of the fee changes, there really are only 3 fee changes. 16 years it was at $365, then it jumps to $450 in 2014, then it jumps to $525. Could do a simple chart just putting that out. I just don't see how other way you would graphically do that. And plus, I think that, if you find a way to do a pie chart or some other chart, I just don't know how that would work, because it's just asking the history of the fees.
I can bake a pie better than I can do a pie chart. Let me just tell you that. I can
appreciate that
just
better,
tell you
too.
right up front. Dr. Stewart, I think Dr. Witcher wants to be recognized. Oh.
Yeah.
Oh. Maybe we should have the board president sit over here. Dr. Witcher, you got the floor.
Well, to explain the reason for the fee increase, you have to go back to the fund condition statement over time and see where our income versus our expenses changed over time. So it isn't it's a level of detail that this doesn't really get into, I don't think, if that's what we're trying to show. I mean, to do something simple like show where our fees have gone over the last 5 years, that wouldn't be so hard. But the underlying reasons for it, where our expenses have increased, you almost have to go back to the fee analysis that was done by the consultant, where they projected out how our fees were too low in a lot of the categories.
Which will be part of this report,
yeah, and so
actually.
it's covered lots of places, and I get what you're saying, because that is sort of a seminal point that you want to make, because you want to justify why your fees went up, and you don't want to look like you're not being good guardians of the public fund, but it's a lot of information.
Okay.
Well,
any?
It's me.
Oh,
I know you can't see me. Well, I was just, I think maybe you just need to add, a sentence or two into this paragraph to illustrate the rationale, for increasing the fees. The reason for the fee changes was due to the fund conditions over certain years, and then maybe add some numbers or data to it to support, the paragraph that you have in here without actually having to, to make the pie chart or whatever. Because I would prefer to eat your pie than to read the pie chart. That's just an idea. I mean, so that you don't have to do too much work to it,
Okay, so in order to just continue the discussion, I've made note of your comments. We'll see what sort of graphic we can insert in this, but you're comfortable with the narrative that's been displayed.
Mm-hmm.
So I mean, I would hate, we don't, this report has to be voted on today. And so we'll take into consideration your comments and try to put in some sort of a graphic that illustrates what we've said. And that will be put into the final report. Dr. Morrow?
I agree with maybe putting the data, the numbers in a format that's a little more pleasing to visual people. My major question is, and when I read this, why did we go for 16 years without raising them? And I'm not hearing any explanation here, and maybe it doesn't belong here. But my big question is, were we responsible for going 16 years and not raising the fees? And what was our rationale? What was our thinking back then without raising the fees on a regular basis?
Okay, I believe we covered that in the last Sunset Review report, and we did have a lengthy discussion about that. But just for the new members, yes, the board's renewal of 365 held for about 16 years. I can comment on at least 6 of those years. There was a revolving door of executive officers. Literally every year, somebody cycled in and cycled out. And when you don't have consistency, it's very difficult to stay on top of things that need to be done. The board has, staff-wise, has expanded dramatically since probably 2010, when the Consumer Protection Initiative came about, and we loaded up our enforcement program with additional staff. So in the last report that was submitted, we did go through why essentially we were in the spot we were in. And it was just a series of, the board had been sunset a number of times, not necessarily because of the job they were doing, but because of legislation that did strange things. And so there was a period of time where the board actually went and became a bureau for 6 months until such time as legislation could move forward to bring it back to a board. So I mean, over the last 4, 5, 6 years, we've seen a board that has really come together, has been able to do a lot of business. My predecessor, Richard DeCure, was able to stay in the position 4 years. I've been so far able to stay in the position 6 years. So we have established more of a stable view and becoming more aware of the time it takes to have a fee increase, what goes into that, and being able to project that. We did have the audit, as you'll recall, the last time around, which was very helpful, and the board did vote to stay on top of things by periodically having an outside auditor come in and review the books and see where some changes might be made. So we are likely scheduling that within the next couple of years to have that come through.
And we had the
Certainly.
big suit.
Pardon me?
We paid the big suit.
And there
too.
was a big lawsuit. So I mean, the reason for trying to have somewhat of a cushion in months in reserve is to be able to deal with things that come up, and including lawsuits or legislative mandates, a number of other things. So we can go back and see whether we can tweak this, essentially what happened for 16 years, why we didn't raise it, and we can add perhaps a little comment as to why that wasn't raised, or at least say, refer back to the report 4 years ago where that was covered. Will that work for everybody? Okay, thank you. Any other comments?
On page 82, number 15, we talk about the SSA position for SB 562. And then on page 83, we talk about AB 1174. Should we do some kind of asterisk to say what they are? 562 is not one of the bills that is current enough that it's in this list.
I'm sorry, Ms. Burton, I'm not following what you're asking. Are you asking about?
When in our description of why we asked for the BCP, we say that for the first one, that it was additional staff to implement SB 562. What is that? It is not in the list, in our current list of bills.
Oh, I see. Okay.
Could you just add that in parentheses? Like, I think wasn't 562 mobile clinics, and
Yep.
1174 was teledentistry EFs. Because I had to look those up too.
So, Sarah, are you following this? So we essentially would put an asterisk that 562 and 1174 weren't in our legislative update.
Yes. I think the reason it's presented this way is because it's asking for the last 4 fiscal years, and so this BCP hit in a different fiscal year than the bill was enacted. So we'll put an explanation in there.
Okay.
Yeah, I don't think they were asking for necessarily a full summary. Just it could literally just say mobile clinics or teledentistry. I think would be fine.
Okay. All right. We've made that note. Any other comments or questions in section 3? Okay, hearing none, we're going to go into section 4, the licensing program. And that starts on page 85. The good news to report in this section is that we have no licensing backlogs in either our RDA program or our dental program. We have a lot of tables here that is difficult to follow, but the bottom line is that we haven't had backlogs during the last sunset review process. We don't have backlogs now.
Through the chair, I just had a quick editorial comment. Reading through the licensing data by type starting on 89, I found this kind of hard to follow. If we could have that title bar maybe repeated at the top of
Yeah,
at
that's going
least
to be,
every other page.
the formatting is going to be done by the publications department. And yes, if a chart is split, that the title line will be at the top of each page. And I apologize. We just couldn't figure out how to make that happen.
The hard copy is a lot better than the
Oh.
Word version.
Really? Okay. But those types of things will be handled by the publication unit. So as what Dr. Witcher's looking at is essentially a table may go on for a number of pages, and you lose track of what you're looking at because the titles along the top don't go along with it. So that will be corrected in the final copy. And that's the same for all tables that essentially are split throughout the report.
And if no one else has questions before page 100, my reaction to question 21 about licenses denied, I'm thinking about the legislation this year that we opposed. And I've wondered if we wanted to say something here about the need for public protection, especially for those displaying drug and alcohol abuse. And because that's paramount to us, it's the reasons that we've taken the actions that we have. Nobody cares, but I still oppose that bill.
Through the chair, I think one of the things that legislation missed was it was designed to get people back in the workplace of the kinds of occupations where it might not be as much of an issue as it was for a healing arts profession.
Yeah,
and that really was.
I think we raised that. I think we.
Yeah, it didn't. Unfortunately, it wasn't recognized. Yeah.
If I'm not mistaken, it was something that was targeted to construction. Right. Yeah. So if we could say that, that's just my own little issue, I know. And then on page 103, when we talk about number 20.
Thank you. I'm sorry, Ms. Burton, what page were you directing us to?
103. And the question is whether all current licenses have been fingerprinted, licensees have been fingerprinted.
Mm-hmm.
So the top of page 24, we talk about beginning the process and blah, 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 blah. But the question is, has everybody been fingerprinted?
So you're looking at 22C?
Yes, yes. And then if you go on to the next page and we talk about the effective date, and we talk about the remaining exceptions, does that mean that everybody has been fingerprinted?
Minus the exceptions.
So then why aren't we saying that instead of all of this other stuff?
Yeah, so we will address that.
Yes.
22C.
If you look at the top of page 104, that's where the response is.
Well, so the question says, have all current licenses been fingerprinted? If not, explain. So Ms. Burton believes we need to say, well, the way the question's asked, have all current licenses been fingerprinted? We, in essence, are we're replying to, if not, explain. So we would start that answer with no.
Or all except those licensees who have been placed
Okay.
in inactive status.
Okay. I've made a note.
I just want to comment, this is unbelievably fast here. I'm impressed. This is going well.
Oh.
This is going well. Last time it was like torture. This is going well.
Last time meaning August or last?
Yes.
Oh.
Yeah.
Well, thank you.
Last time it was like a Giants game.
You mean a Giants game going badly? Okay.
You haven't finished yet.
Okay, so we'll make note of that and provide additional clarification. Are there any comments or questions remaining?
So is page 131 is a part of this section, right?
No. Page 131, no.
Okay.
This section goes to page 117.
Okay.
I have a question.
Mm-hmm.
On page 115, and we're in C, the second paragraph, starting off with a licensee who fails to pay a fine or comply with the order of abatement may be referred to the board's, so is this a yes or a no, or is really a maybe? And if so, if it's a maybe, then what happens? I think that this deserves a more of an explanation, because it's putting it out there for questioning. So I guess my first question is this correct? So they may be referred to the board's enforcement.
Give me a moment here because it's relating to a CE audit. So let me just make sure that I'm putting it into the context here.
Okay.
I'm trying to think. Okay, so if a citation has been issued for for not meeting the CE requirements, a hold is put on the license. The recipient or the respondent has the opportunity to ask for an informal conference to discuss the issue. The citation may be upheld, dismissed, or modified. And the bottom line is that it could be referred for disciplinary action. So non-payment of a citation could be referred for disciplinary action. Doesn't necessarily have to be referred. Right.
guess when going through this.
Let me, Ms. Chappelle Ingram, let me make a note of that and read through the rest of the section on CEs and see whether we need to clarify that.
Okay.
We could easily clarify that.
About 3 times, and maybe you have some. Sometimes what happens is that when writing these, sometimes you're so close to it.
Oh, you're absolutely right.
Yeah, and you have it in your head, but it doesn't get translated onto paper. So
We certainly have the authority for non-payment of a citation to move forward, bringing an accusation against the licensee.
yes.
So perhaps we can change the word to shall.
Okay, and in terms of authority as well.
Right.
So okay.
I'll talk about it with the rest of the staff, and we'll probably pull legal in and just see whether something needs to be tweaked. Dr. Lai.
I just have a question. There's no mention of any provisions for recertification of foreign dental schools. If they're not CODA approved, how do we?
Are you talking about a certain section?
113, 31.
Are we through with the continuing education discussion? Okay.
So
Page 113.
the reevaluation process through CODA is obviously different than the foreign dental schools. We have no mention of how we recertify foreign dental schools in 7 years. It's supposed to be reevaluated every 7 years, but there's no mention of that. Because before it was just one, now we have 2. I think we need to set something for future.
Is your comment relating to the answer to the question, or is it a side issue that you feel the board needs to discuss in the future? Because this says how many schools are approved by the board, how often are approved schools reviewed?
So I'm just saying that we have a process to review every 7 years for CODA approved. But we don't have any mention of foreign dental schools. So it's like something's missing there to me.
Okay. We'll go ahead and take a look at that.
A comment. CODA is the one that reapproves schools every 7 years, not the board. Now, the board reapproves board-approved schools, but not CODA. I believe that there is I can't remember the number now, the regulation number, but that the executive officer of the board is to keep a list of all board-approved schools. And I think those are listed under 31. Those are the only schools that are approved by the board. The board does not automatically approve all CODA-approved schools.
Okay, so
at
then
the present time. We have a list of, 8 schools only that the board approves. However, in order to get licensed in California, you must have graduated from a CODA-approved school. But that doesn't mean that all CODA-approved schools are approved by the board.
Okay,
I know it's kind of mind-boggling, but...
So are we going to be following the 7-year rule then?
Well, at number 32, I think, question number 32, doesn't that address your question? That the board is responsible for approval of international dental schools on standards established in Business and Professions Code CC 36?
You're right.
Okay.
I'm sorry.
Okay, so 30, I think 32 answers your question.
Right.
Okay.
Thank you.
Okay. Right.
I think we're...
I think it's well understood that we approve international schools or foreign schools. The board does every 7 years.
Right.
We also have the right to inspect those schools at any time that we so choose, which I don't think we've done in the past, to my memory anyway, but we have the right to do that.
Thank you for your comments. Any additional comments on section 4?
It's just a slight comment. I don't know why. It's on page 116, and it is the second paragraph as of 4/30/18, and it is about the 183 licensees. And it's talking about failed the audit. My question is there any chance that they'll ask about the failure in terms of, the failed audits?
Well, the failed audits essentially mean they don't have the number of units that they needed to have.
Yes, this is true, but
Right.
What we're doing about it is,
Well,
that's in another section.
well, we issue that's where the citations come in, and so we were talking about just up above what happens. So all this section is the competency requirement discussion starts on page 114, and it goes through and specific questions are asked. So I think maybe see above, what are the consequences for failing the CE audit, is the answer to your question. What happens when these people fail the audit?
And I just didn't, yes. And it's, what are the chances they'll ask about it? And what is our expanding on that?
They did ask about it. It's right above. So it's letter C. What are the consequences for failing a CE audit?
It's on page 115.
Right here.
Yeah.
That's where I made the note. Okay.
I think that answers your question, Ms. Chappelle Ingram, unless I'm not understanding your question.
No, it's answered.
Okay, awesome, thank you. Any more questions in section 4? That's okay. Uh-huh.
Would you please use the microphone?
Your mic, Dr. Morrow.
Thank you.
The board is authorized to approve international dental schools that meet the requirements of 1636.4. Also, it says the board is authorized to accept the findings of American Dental Association Commission on Dental to approve or reapprove dental schools. Do we have an understanding regarding Canadian schools?
No.
The equivalent of CODA in Canada, which is the Commission on Dental Accreditation for Canada, their website states that they consider all U.S. schools being accredited by Canada. It was my understanding that that was a reciprocal agreement between the Canadian accrediting body and the U.S. accrediting body. I sent an email request for clarification to that to Dr. Sharon Tooks, who's met with us previously from CODA. And unfortunately, I did not get a response back from her prior to this meeting. But I was curious to find out if CODA considers Canadian schools as approved the same way that Canada considers United States schools as approved in Canada. If that's the case, I think it might need to be reflected here under international school approvals, or considered anyway.
I would say my hesitation in including that at this point is that the board hasn't discussed that.
Right, and I'm not, I agree with you. So
I think that it's an excellent question for a discussion at a future meeting, but I would prefer not to insert something into the report that the board hasn't discussed and doesn't have, we don't have, not only do we not have a discussion to back up whatever we say, we don't have the background right now to be able to have that discussion.
Right, but depending on what that response is from CODA, right, and I agree.
Right. And as I see this process developing, should the board agendize something during the sunset review process that is related to what we have already put in our report, there's no reason why we would not be able to update the legislative staff about any concerns that may be coming forward. But I think that this would require a robust discussion at a future board meeting. So we'll make note of that and bring that back around for a future board meeting.
Thanks.
Okay. I see heads shaking, so people are still awake and.
But in
Awesome.
the back, and I can't find the question now, on the last section, we do talk about Canada approval in one of those questions. I just remember reading that about foreign dental schools.
Hopefully when we get to that section,
Yeah.
because it's not ringing a bell, but that certainly doesn't mean we haven't stated it somewhere in the
Okay.
report.
I'll find it.
Any more questions or comments? And I'm not going to rush you because we are moving along pretty well, and we do have the time. So some of the sections later on are going to probably require more discussion. It is 11:20. Are we ready to move on to section 5? If in the course of discussions under section 5 we need to go back, that's great too. So just speak up, okay? So we're going now into section 5, which is our enforcement program.
Through the chair.
Dr. Richard.
Yeah, I don't want to digress too much into editorial comments, but on page 118 under improvement, second paragraph, it really, that needs a little clarification. The average days was 866 days compared to the previous fiscal years. Average days for what? So I think it just needs a little clarification there. And now the thing that also, if you look over on page 119 and you find the average days in the narrative doesn't match the average days for accusations in the table, nor does it match the average days to complete discipline. So
let me address first your first comment on 118.
Sure.
So the average days for what refers back to formal discipline, if I'm following you. So you're looking at PM4, which is defined as formal discipline. So the second paragraph refers back to formal discipline. Does that make sense?
Well, I understand that, but it doesn't say that. So, I mean, again,
okay.
This is a grammatical thing. I mean, this is an editorial comment only. Just
okay.
Yeah.
All right. Now, if you wouldn't mind going through the specifics because it is very important that we make sure that numbers match up. And so if you have specifics you'd like to talk about on page 119, if you could walk us through that.
Sure. Well, we see that figure 866 days come up also under performance measures, but I don't see that in the table here.
Okay, so you're looking at page 118.
Yeah.
And then what table are you looking at?
The table 9A enforcement statistics.
Okay. All right, and Carlos, if you'd like to come to the table, I did not bring up my marked up copy that shows essentially where our numbers came from and what they match up to. No, Dr. Witcher. So Dr. Witcher's first comment on page 118 under improvements, go down to PM4. He said that the second paragraph doesn't seem to correlate to the first paragraph. So in essence, what I believe this section says is that during the fiscal years that we're reporting in this report, the average date to address formal discipline is 886 days compared to the last reporting period, which was 998 days. So in essence, what has happened in the formal discipline, and if you go up to formal discipline under question 34, formal discipline tracks the average number of days to complete the entire enforcement process for cases resulting in formal discipline. Formal discipline target is 540 days, and the board's average is 886. Okay? So then going down now into the paragraphs that Dr. Witcher has brought to our attention, somehow he feels that the second paragraph under improvements and right above question 35 just needs to be a little more clear what we're saying. Is that correct, Dr. Witcher?
Yeah.
Okay. All right. So I think I've got that. We'll work on that. Now, you had additional comments about something we've said in the narrative doesn't match up with Table 9A or 9B.
If you go to Table 9A, the last heading is discipline. Average days to complete. Go across that. It's 1645, 1613, and 1863. I think, should that be 886 average? I mean, I realize it's going to, if you look at the other statistics going across, they more or less average. That one does not. That one is like 1,000 over. So I think it's just a numerical error. But I thought it was, like you say, we want to be clear about, our time to complete discipline. That's a number they look at. That's one of our benchmarks.
Right.
So I may be missing something there, but that just kind of jumped out at me.
Carlos, do you have any notes?
No, I don't have any notes.
Well, so we'll mark that.
I have it marked, and we have to take a look at it again.
I mean, there are a number of benchmarks that are really very helpful. One is, time to file an accusation, time to complete discipline, time to resolve a complaint. I mean, I think those are three of the kind of the major things that we always look for in terms of our timelines.
Okay, we will look specifically at that line. So staff will be going back and looking on page 119 under the category of discipline, average days to complete. And we will see how we correlate that back to the comment made in the previous page. Is there anything else, Dr. Witcher?
Maybe just check those numbers in the table, to make sure they all jibe with what we're saying in our performance measures.
I have a question.
Go ahead, Dr. Lai.
The numbers kind of jumps out at me, right? Is there a way to, in light of that, break it down to in the phases of because that's like 3 years, right? So if we can, if I was looking at this and I'd say, wow, that's a long time. So is there a way to say the initial entry and how long it takes, and to break that number down into how many parts it takes to get through a review of a case to completion, instead of making this gigantic number. Is there a way to break it down? Say it takes, 100 days to do this, 90 days to do this, so it doesn't look so.
It looks bad.
Yes. And so,
It is.
and even though it has to go through, as Dr. Witcher was saying, it has to go through a certain protocol, we may need to break it down so they understand it and they say, wow, that's a big number. So they're saying, why? This doctor is practicing and it takes 3 years for us to finish that. Well, why? That's going to come up. Mm-hmm. So if we could break it down and say, okay, the initial complaint to that, and break it down and segment it, maybe it's a little easier to digest.
And to some degree, we have done that in the table. Dr. Witcher, if you want to take it from well, so in other words, when you look under complaint, it says the average time to close, how many are pending. So it's sort of already broken it down by the complaint side, the accusation, how long it takes to file an accusation, how long the discipline takes. At some point in this report, I think we have mentioned that numbers can be skewed depending on after a proposed decision has been adopted, if somebody takes it to the next level, that writs pull out the timeline even further. I think we've addressed that in certain places here in the report, but we will look into it and see whether we can provide further clarification.
I just think that under improvements, that second line, and you have all those numbers skewed together, like the 2014-15, maybe that paragraph should be more explanatory. And it says during fiscal years, blah, 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 and then that big number jumps at you.
Okay.
So maybe if we can.
So you're commenting on Dr. Witcher's comment that that second paragraph under improvements needs to be clarified.
It just looks like everything was hashed together and figured that out.
All right. We will go ahead and take another look at that. Any more questions?
Yeah, if you look at the table on 9B, there the averages do sort of work out. In other words, average days to close is 265, and you can see under investigations going across that matches up. Non-sworns, average days to close, that matches. Sworns, that matches. So, and this chart here really breaks it down pretty nicely, I think. I mean, you could put it in a visual form if you wanted to, but I think, the staff, I think, is pretty used to looking at tables.
Yeah. Okay, so we'll take those comments into consideration and see how we can clarify that part. How about anything else in this section?
On page 131, where we talk about cost recovery, one of the big issues for us is in terms of what we're able to collect is the ALJ decision. And this does not reflect where the order says we cannot seek recovery.
Are you referring to a specific question on page 131? I mean, the questions get pretty specific, and so we tried to pare these down and answer the questions. But if there's a specific place you think we need to say that, yeah, we can address that in essence, what you're saying is when a decision comes down after being heard, that the respondent has provided financial information to say that he can't pay, and based on case law, it's determined that the ALJ does not put cost recovery in the order. I'm not quite sure where we could put that, but staff will take a look and see whether we can insert that.
I think it might be actually in 48.
Right, I was
You
going to
talk
say the
about
thing. Third
presiding
paragraph.
ALJ decides how much of the board's expenditure will be remunerated. So it's, I think that might address it.
Tom, could we go back to 123?
Wait. Before you go back to 123, let's just tie up this one first.
Oh, I'm sorry. I thought we had that wrapped.
I'm not sure. So, Ms. Burton, does 48 go where you want it to go in answering your question about the
third
ALJ's
paragraph.
decisions? So the board's request for recovery is made to the presiding ALJ, who decides how much of the board's expenditures will be reimbursed.
Okay.
The ALJ may award the board full or partial cost recovery or may reject the board's request. In addition to cost recovery in cases that go to hearing, the board also seeks cost recovery for its settlement cases. Is that good enough? I can take it
Yes.
off the list? Awesome, thank you. Okay, now who wanted to go back? Dr. Witcher, and what page?
123, number 36.
Okay.
It says, what do overall statistics show as to increases and decreases in disciplinary action since last review? And we kind of give two little bullet points there talking about enforcement aging. And I don't know if we want to mention this, but it kind of jumped out to me in the table up above that the Attorney General case is closed. That's in the middle of the table there. It goes way up from 152 to 283, and I think they hired a bunch more people. And maybe it isn't really relevant to us, but the fact that they were able to close substantially more cases in that year might indicate a positive trend.
Okay.
So, we usually point to the Attorney General's office as being the bottleneck.
Right.
So maybe we should say they are doing something about it.
All right.
Or trying, just a thought.
Okay. So you're suggesting that we put a comment in answer to question 36, recognizing that the AG cases jumped from 152 to 183, likely because they were able to hire more deputy attorney generals. Okay.
In other words, we are moving in the right direction on reducing our timelines.
Okay. This is an awesome discussion, and I so appreciate that you all have done your homework and that you're coming up with these things. I mean, as somebody commented from the beginning, staff lives and breathes this, and after a while, we don't even really see it, and we think, oh, we said that, and then it's not obvious that we did say it or we didn't say it in a clear way. So I do appreciate your attention to this. This is also a good training, if you will, so that now that you're familiar, perhaps as we go through our quarterly meetings and you see the statistics in your board meeting material, you now know what to look at a little better. And it's just continued effort on everybody's part before the information finally sinks in, and then things change and we have to start all over again. But so I do appreciate that everybody has participated in this. Any more comments on our enforcement program? Ms. Chappell Ingram.
I remember a time I was first on the board, And I kind of made I made an outrageous statement. I haven't made one since then. I don't think. But it had something, it had something, by the way, despite all of that, and you guys are up close, this is a phenomenal job that the staff has done. It's great. But under page 128, number 41, and I don't know where this fits. This may fit somewhere else, but I do remember when there was a sting operation, or when enforcement does go in and they'll find some unlicensed.
Mm-hmm.
They're operating in garages, and then there also may be some individuals there getting their teeth pulled or whatever. And I do remember, and it probably had something to do with access to care, that pamphlets, Jocelyn, I believe that pamphlets were being handed out, and that the so-called patients were actually guided to maybe community clinics or some others, but there was an education through handing out of pamphlets, but there was an educational process. Is that still going on? And if so, should that be in here anywhere as to our efforts to help those that are being?
Yes, I'll have, I think that this is two parts. So, yes, your outrageous comment.
Oh, you remember it.
Oh, yes. Oh, yes. I remember it. I remember it. No, she doesn't repeat her mistakes. I can vouch for that. And you can see in this report, we've also reported the SCUD mission that was done in June of this year. I'll have Chief Alvarez comment on that. But I think that in another section, perhaps under access to care, I hope we've addressed outreach, which again has been somewhat limited to underserved areas based on the board's ability to travel. I know it is in state, but we'll be working on that too in future access to care committees that you're, I believe, chairing, so we can be talking about this thing. So let's break down the question. First, have Chief Alvarez talk about what they find when they go into these sting operations, and then we can see whether we can address the second part of your question in terms of notifying the patients who are going to these unlicensed people about outreach to them about the dangers of that and where else they can go. So I'll hand it over to Chief Alvarez.
Hello. So I could answer that question there. So usually when we go in and we do these sting operations, it's always in a low income area, and again, they have no health insurance, and so they go into these dental labs, and they're sold on, yes, we're here to take care of you, the community, and they kind of sell it because they're saying we're working for you, for the people, because of the nationality, and so they do these outrageous treatment plans where they go in, if you come in here 6 times. Each time we'll charge you $100 for each treatment, and usually they always come back more than 6 times because all the treatment has failed. So they end up paying anywhere from $1,000, $3,000 plus. And so then we recognize this. We go in, we stop the treatment, everything that's going on in those dental labs or in the residence. And what we do is, like you said, so education, community outreach, access to health. We do have a list of free clinics in Los Angeles County. And so when we stop all the procedures, we have patients there in the waiting room. We refer them to these free dental clinics. And we then, at that time, we do the community outreach. We do the education to say, please don't come into these, these type of places because they're actually taking your money. And if you go to these dental clinics, they're free. They'll give you, other alternatives to care. And so that's where we send them to, all these dental clinics. So all the patients, when they leave with a handout from all the dental clinics in Los Angeles County. Yes.
Did that address all your questions?
Yes, I just wanted to make sure that some of it was reflected here.
Okay. Any more questions on section 5?
I just have a quick question. Did you actually investigate 51 locations in 1 week?
We actually
It's amazing if you
yeah,
could.
we
if
worked
you
on
did.
51 cases. So we went out. Some were complaint on more than one place, so we were able to consolidate into one. So we went out. It was, I would say, it was 30 to 40 locations. We went out there in 1 week, and we just started working really fast, and we started going to all these locations.
I mean, that's amazing work.
Yeah. No, I gave kudos to my unit there because, like I said, we went out from the first day. We started on Monday morning all the way to Friday, and it was just nonstop. We started at 7 a.m., 8 a.m., and we weren't stopping until like 6 p.m.
It is amazing to be able to do this, and so we transported our enforcement staff from Northern California. Most of our cases are in Southern California. Most of this unlicensed activity is in Southern California, so they can get an awful lot done. They divided into teams, and they all had their direction on where to go. They came back on a daily basis and debriefed, and the reports were due within a certain period of time. It really has worked very well. And so, yes, we're happy to report this. And our investigators actually really like doing this bang up kind of stuff, charging into someplace.
But unfortunately, I'm the one
Official.
that has to go and sit at the dental labs and get examined. So that's the part I don't like. But everybody likes to be the hard chargers, but I'm the one that's sitting on the chairs. So
Yeah, that we do undercover. And so, some of our folks, particularly in the Botox discussions, you make an appointment, you go in, and people who are doing Botox that shouldn't be are just ready to inject, and we go, whoa, wait, badge here, not supposed to be able to do that. So they enjoy doing the undercover work a lot. So most of our cases don't require that, but every now and then it's nice for them to get out and do some of that more exciting stuff. So you've got a good staff. The board should know you have an excellent staff in terms of protecting the public. Any more questions or comments on section 5? I think this is the section that, and I apologize for not bringing my former marked up copy. This may be the section where Dr. Stewart made the comment about how we were categorizing complaints. And I just wanted to clarify where something was determined routine or extreme or whatever, those terms we didn't change because they actually are reflected in a DCA policy. So our responses were directed at the definitions that are used within the DCA policy. So while, yes, it's noted that the board wants to emphasize that it's aware of fraud going on in terms of excessive treatment, not only excessive treatment actually being done, but excessive treatment being suggested, and then along the way within a second opinion, it's determined that it's not necessary. We do go after those cases strongly, and we don't mean to say that they're routine, but we're just defining that process through the Department of Consumer Affairs breakout of processing of consumer complaints. I know you don't look thrilled with that answer, but the whole section is prefaced by, do you utilize the complaint process of the complaint prioritization process of DCA? And the bottom line is yes.
And I guess I remember that conversation and coming from a patient that moved to a different community and was told that he had 10 new cavities, and he thought to call back to his previous dentist, and we had him come in and look at it, and when he had no decay, and all of a sudden, and so when that sort of thing happens, I just think it's terribly egregious, and it's worth stopping. And so we encouraged him to do the appropriate thing and file a report. So I'm sure that's moving. But I think the board would agree that that's a very serious offense and needs to be curtailed. So I'm good with that. Thank you.
Are there any more comments or questions in section 5? Seeing none, we've got probably about maybe about 15 more minutes to work before we take a lunch break. Thank you, Carlos. And so let's push on into section 6. There weren't a lot of comments on section 6 and section 7 last time around, but this is another opportunity for you to look at it with new eyes. Are there any comments on public information policies on section 6? Ms. Chappelle Ingram.
Yes, on public information policies. I don't see where we mention our teleconferences, our one-day conference from our offices or from other areas where we have like emergency or urgent meetings. I know that it's posted on the website. I know that it's posted to the public, but we don't necessarily mention it in here. Should that be mentioned? Because we do it, we may as well.
Well, we've done it in the past, but legislation was signed by the governor that's going to severely restrict our ability to do that in the future because it's going to require that a quorum of the board be in one location. Which is in essence defeats the purpose that now we didn't utilize teleconferences a lot, but in emergency situations we did, and that allowed us flexibility. But it's my understanding we will not be able to move forward with that based on the legislation that was signed that require these teleconferences to have a quorum. I believe a quorum of the board needs to be in one location.
In one location.
So that's. And then one might ask, well, if you have the quorum, why would you need to have a teleconference? Because you could have the meeting without the others chiming in. So we will be discussing that further. I'll mark this down and see whether it's something that should be inserted and would somehow relate back to a question.
Well, if a bill is passed, then there's no need to put it. I was unaware of that.
Yes. Okay.
Okay.
Dr. Witcher?
I have one under 7. I think this got mentioned under new issues as well, but I think we have somewhere down for a future agenda item online orthodontics.
We have teledentistry on a future agenda.
Okay, all right. So that's the same thing.
We have teledentistry on, yeah. Well, but
okay,
just so yes, we have that. We have that noted for a future discussion. Okay, again, we're looking at section 6 and 7. 6 is public information policies. 7 is online practice issues. Okay, I'm thinking that this is a good place to break. We'll come back after lunch and work on section 8, workforce development and job creation. I'm looking into my crystal ball to think how much more the discussion is going to be. I'd say let's break for 45 minutes. So the board will reconvene at 12:45 in this hearing room. When board members are ready, we will escort you into our office. We're going in and out the door, this front door, rather than our outside doors for certain changes in our policies. So I'd say we can go into recess until 12:45. Okay, thank you.
Call the meeting back to order. No. Karen?
Yeah, thank you. Just a reminder to board members, if you haven't paid for your lunch, make sure to see Jerry before you go to the airport, please. Her interest rate is very high. Okay, we're on section 8 now of the background report, and that's page 136. Workforce development and job creation. There really weren't a lot of changes from the August meeting in this section. Are there any comments or questions on section 8? We have about an hour and a half to get through the remainder of the report so that we at least allow 45 minutes for closed session. But board members will have to adjourn by 3 o'clock so that we can make sure we get everybody to the airport. Okay, so we're on section 8. If everybody's settled, any comments or questions? Seeing none, we'll move to page 139, section 9. These are current issues. It's a little misleading in that it's called current issues, but essentially they're asking about uniform standards, which we implemented, I believe, back in 2014. It talks about the Consumer Protection Initiative regulations. It also talks a little bit about BREEZE implementation. As I said, I don't believe there were a lot of comments on this section, but now's your opportunity to comment.
While people are still looking at section 9, can I go back to page 138 in section 8?
Absolutely.
Just for clarification, under 64, workforce shortage. And it says the board monitors reports from OSHPD.
And they haven't put out any recent reports relating to dentistry.
Okay, but the board has formed the Access to Care Committee to review the studies. So it's just to review the studies, to work in collaboration with the Select Committee on Health.
Right.
Okay. I did not know that.
Oh,
and so this is really good to know.
Well, typically any reports that come out relating to access to care, we would bring to the Access to Care Committee to essentially review and respond if necessary.
Okay.
So the board staff is actually going to be working with OSHPD to see where we are in terms of producing more reports, smaller reports on a regular basis in terms of workforce shortages in underserved areas. OSHPD has had access to our survey information that is required to be completed upon renewal by all licensees. So we're going to be working in the next year to see whether we can get updated data, and then we would bring that data to the to your Access to Care Committee to see whether there were any trends established or if different policy decisions need to be made to address whatever we find.
Great.
Okay.
This is great. Thank you.
Good. Any more comments or questions on Section 8, workforce shortages, or Section 9, current issues? Okay, we're moving on to section 10. So this essentially is the big section that we've gone through a number of times. There was really only one question that Ms. Burton and Ms. McKinsey had brought up, that they felt that the response was a little short. So I did make adjustments to that. And I'm looking for what it was. It was the call Curtis. Okay, so it's on page 156, issue number 9, regarding patient notification and record keeping. And so the response was modified to say, as was mentioned in the background, the board has not received a significant number of complaints from patients about dentists selling their practice without notifying their patients and who subsequently end up harmed by the new dentist. Since the last Sunset Review, no additional complaints have surfaced, and the board is not aware of any trends in patient abandonment leading to patient harm, but will continue to monitor the situation. Do I have a thumbs up from Ms. McKenzie and Ms. Burton? Awesome, thank you.
Just a comment.
Mm-hmm.
In the last week or two, I've had 2 patients that have shared with me their distress and their unhappiness over the fact that they felt like they were abandoned by their dentist. And in fact, I think it's out there, it's happening, but they don't know how to report it, or they choose not to. It's just whatever. But I know that we can only get involved when there's a complaint. But I'm just, for some reason, it's not raising to the level that all they wanted. So it's kind of frustrating to hear that, and then to understand that the dentist is no longer in the community. And in one case, they alleged that they had given the dentist like $3,500 to complete some treatment, and they don't know where that money's gone, and the treatment hasn't been completed.
You're correct, Dr. Stewart, in that they should be filing a complaint with us, though I believe that if the board decides that you would like to discuss this further at a board meeting, we can certainly agendize it for a future board meeting. Because, even with just one complaint, we can move forward saying that we want to make sure this isn't a trend and people may not be reporting it, and so we may not be finding out how prevalent this is. But what would we need to do in statute or regulation to ensure that that somehow this issue is addressed? So I'll make a note of it to pursue this.
I'd be in favor of having that on a future agenda. Does anybody share my concerns?
Yes, I do.
Does anybody object to having it as a future agenda item? Okay, we will have it as a future agenda item. Thank you, Dr. Stewart. Any other comments or question on Section 10? These were issues that were identified during the last Sunset Review period. This is our response to those issues. This is what the issue paper will look like after we submit our current report to the legislative staff. They will come back with a background report that will be distributed to the legislature and to the members of both the Assembly and Senate Business and Professions Committee, and they'll have their staff recommendation, like this format is here. They'll identify what the issue is, and as you see in each one of these items, they've got the issue, they've got a little background, they've got the staff recommendation, which is their recommendation, and then this will be an opportunity for the board to give our response to the issue that's brought before us. So that'll be happening in February, end of January, February, March. Okay? Okay, if there's no further comments or questions on Section 10, prior issues, we're now going into new issues. And I think it is important to spend a little time on new issues. The first one being, so these were issues essentially that were raised under the prior sunset review that haven't yet quite been completed. The first one was whether or not to move the dentistry fund and the dental assisting funds, whether to merge those, and the board did vote to do that. It's just now going to take time to be able to do that, but we do need the statutory authority to be able to do that. So once we get that statutory authority, we can work with the budget department to see what needs to be done to achieve that. Issue number 6 was regarding foreign dental schools. Now, this is an important one. The board has expressed for probably nearly 10 years, essentially, that the board doesn't really have the expertise to be able to evaluate foreign dental schools, doesn't have the resources to be able to do so. We have been very blessed by having active members on the board who understand the process, as Dr. Morrow. We've had Dr. Witcher, who has participated in this, and Dr. Lay in particular, calling out those 3. And we've had others participating too. But, Dr. Witcher and Dr. Lay are going into their grace period next year. And I think that those are going to be difficult shoes to fill. And, then that's going to rely solely on Dr. Morrow's shoulders until we can train up other people to understand what the process is. We have discussed, and I think it's important to bring up, that the institutional standards by which we currently measure foreign dental schools have been outdated. And they were initially developed in accordance with CODA standards at that time. We have recently come to the understanding that it appears the board will never be able to catch up in recording, if you will, the current CODA standards into our regulation, because it takes so long to get our regulations through that most likely when we get them through, the CODA regulations or the CODA standards will already have been changed. We will never get caught up. And it's really unfair to say that we are able to evaluate a foreign school if we're not using the same evaluation tools that the schools in the United States would have to essentially meet those requirements. So we are hoping that we will get relief during the sunset review period and essentially get out of the business of approving foreign dental schools. Does anybody have any questions about this particular issue, number 6? And do you feel that we've made the argument in what we've said here?
No question, but a comment. This is so well done, this section, because this has been such a issue for us, but it is laid out so well. So that's my comment.
Thank you.
Makes the case for why we shouldn't be in this business.
I agree. I want to express also my appreciation for, I think, the concise but yet complete position that you have stated here. And we could go on for multiple pages with this, which would not be, I think, in our best interest, because that's going to be kind of boring to people. But I think the important things have been stated here to the committees, basically that at the time that this provision was made, there was no other alternative. There is now. And as a result of that, there's a better way to make it happen. It's not that we don't want it to happen. It's just that there's a better way to do it. And I don't think that the dental board is equipped to or should be in the business of, so to speak, approving foreign dental schools, and certainly not from a standpoint of ensuring that their education is equivalent to that in the United States, when we have to measure that with a different measuring instrument than what the schools in the United States are measured with. And I think that's important for the committee members to understand. And I think that's spelled out here. Now, possibly at the Sunset Review hearing, they might have some additional questions or want some additional information, which could be added to that point. But I think this is good.
All right. At the hearings that will occur next year, the committee members will have gotten a version of our background information, and the issues that are outlined will be providing a response, but they will only be picking a few issues that they want testimony on. So staff will certainly be working with our consultant on the Assembly B&P side to make sure that some of the very important issues that we would like addressed, hopefully we'll be able to give them enough information to be able to move forward in that direction. Okay.
Oh, yeah, I just want to make one quick comment, and that is I agree with Ms. Burton and also Dr. Morrow, and I want to thank the staff for putting this together. This is great argument for us getting out of the business of approving any school, not just international school, because we do have a very good national standards, to follow, to utilize. So thank you very much for your work.
Thank you.
Karen, is that over here? Is that going to be a statutory change or a regulation?
Statutory.
Statutory.
Mm-hmm.
We're not wordsmithing this, but towards the bottom of the first paragraph under B6, under 6, the Committee on Dental Accreditation should be the Commission on Dental Accreditation.
I'm sorry, what page are you on?
I'm on page 170.
170.
About 3 or 4 or 5 lines from the bottom of the first paragraph, right in the center, where it says Committee on Dental Accreditation and then CODA.
Okay.
It should be Commission on Dental,
yes,
not
okay.
Committee.
Thank you. Good catch.
Your staff and readers might not catch that because they're both C's. So.
Thank you. Item number C on page 171 is also going to be critical. Whether or not the practical examination whether we would be required to bring that back. I think that we have identified all the steps that occurred in the process and that open meetings were held and that the decision essentially was made that the board does not believe that the practical examination for RDAs is the best way to evaluate whether or not, they should have a license. Also, I think that the board has emphasized that bringing back a practical examination for this professional level could be construed as a barrier to licensure. So we don't know whether there's going to be an argument brought against that, an argument whereby people would want to bring back the practical examination. So I would recommend that the board continue to study this issue. This is a pretty comprehensive summary, if you will, of how we got through the process. And I want you to feel comfortable knowing this information in the event that we have something come forward where we will need to respond. So I think it says it all here. Any questions or comments about the RDA practical examination? So item number D on 173 basically is this this information we do collect and is required for renewal of licenses within the dental board. When this legislation first passed, the requirement was for us to collect it and report it, and we reported it in raw data form because we didn't have the resources or the staff to be able to buy the appropriate program that would essentially translate the survey into some valuable information. We have received invitations, if you will, from different organizations that they would like to come in and help us work this out. And so we have just noted that we will be working with different organizations to see if we can get any valuable information out of those required data points that licensees fill out. Initially, the legislation came about to ask questions that were later determined to be illegal, so they're not mandatory on the survey. And so we'll stay tuned for a future board meeting. We'll be reporting on this data, hopefully in a useful way. And it'll make more sense as to, we'll, of course, give you the background information about how this came about in statute in the first place and where we are now. So we'll be reporting on that in the future. Item number E on page 173 is whether the board should be conducting continuing education audits for RDAs and EFs. And the board does agree that this is important. Just to give you an update, what we're hoping will come of this is essentially the ability to get another staff position to be able to assist with this. This is very labor intensive to send out the audit letters, to follow up on whether or not anybody responds. We do issue citations for non-responses, and we are issuing citations because unfortunately there is a high level. There's a high level of licensees out there, both dentists and RDAs and DFs, who are not meeting the CE requirements. And we're not talking about they're just short 1, 2, or 3 units. It's like they've only done 1, 2, or 3 units. So the citations, generally, there are 2 causes for the citation. The first one being, on your renewal form, you check the box that you had completed these. That's a lie. That's a violation. That's a serious violation. And the second part of the citation essentially is you didn't do your total number of units. And we give them a time certain in which to complete those units. Again, if people don't pay the fine, there's the hold automatically put on the license, and the license cannot be renewed. So, as I said, it's a time-consuming process to send out these audit letters and to follow up with everything. But we're already doing that, so we're hoping we'll get some relief to be able to get another staff person to assist with that. So there were really no new issues identified by this report. But then we go into number 3, new issues not previously discussed in the report.
I have just a question and maybe a comment regarding the previous section on continuing education. I believe there are other boards and bureaus within the Department of Consumer Affairs that require submission of documentation of continuing education at renewal, not simply checking a box and signing that you have done it, but you actually have to submit documentation that you have done it. Have we considered, it seems like we have a fairly high percentage. When you take the number that we actually audit and take the percentage of those audits that are not in compliance with our requirements, and then you look at the number of licensees that we have, and I'm talking about dentists, that's a high number of licensed dentists that are not complying with our continuing education. I don't remember now, but I calculated, but it was in the hundreds. Way too many. And we're just saying, shame on you, that's a slap on the hand. And that, to me, is saying something about that person now. If they falsified an application to get a license, and we documented that they falsified it, then I hope that we're not going to give them a license. Now they're falsifying a document to renew the license, and we're just slapping them on the hand. And that, to me, seems to be too little too late. I would like to maybe consider possibility of requiring that proof of continuing education be submitted at the time that the application for renewal is submitted. I have a family member that has to do that every 2 years, and she's licensed with a agency within the Department of Consumer Affairs.
We'll put that on the agenda for a future meeting, because I think that I'd like to give the staff the opportunity to give you background information about the challenges that might occur in doing so. So we will put together all the information and bring it to a future meeting for discussion. In the meantime,
The best I can ask for.
in the meantime, we are conducting the audits. We are finding that for whatever reason, people aren't complying with the requirement, and we're moving forward in that direction. Okay. Mm-hmm.
I'm not at all against that idea. The only thing that I want to point out is that now you're talking about a huge feature change on Breeze, because we renew online and to require us to upload all of the documents and all that, you're talking about a huge cost of adding that feature into the Breeze system. So
I love the way you think.
If anything, one idea would be maybe you randomly select the renewals in advance. When you send out the renewal notice, put that on there that they've been selected for audit. And that way, when they do submit it, they probably have to send in, paperwork or something like that. But really, you're talking about a huge cost of adding just one little feature to the Breeze system.
Well, there are other options available out there too. I think that we will have staff research and come back. A lot of boards are going to companies that do this, that track it for licensees, and then the board would decide how to move forward with something like that. And when a licensee is audited, essentially they would send in this document that this company is monitoring on their behalf. But Senator, Dr. Lay is correct in that make any change the board makes to Breeze is going to be costly. It's going to take a lot of time. So right now we are in compliance with the requirement that CEs need to be completed upon renewal, and so there's no urgency to move forward with making any change, but we will bring this back to a future board meeting with all the options, or many of the options available for discussion, and have a robust discussion about it. Okay, thank you. Okay, so now on number 3 on page 173, we go into the new issues not previously discussed in this report. So it's important that the board understand where staff essentially was going with some of these things and clarifying these things. We do have it on a future agenda to discuss what Dr. Morrow had brought up, whether or not our licensure by credential requirement of having 5 years of clinical experience or some combination of other things, a 2-year contract to work in an underserved area or as a faculty member of a school. We'll be bringing that back for future discussion. But at this point in the Sunset Review, we're talking about cleaning up a few things that would be helpful to staff until we can get to the point where we move forward and perhaps change the requirements for certain pathways to licensure in California. I recently received a notice from the American Association of Dental Boards and ADA that a task force has been formed to look into essentially licensure across state lines. Actually, in the report that I read this morning, it does mention perhaps that these organizations are going to recommend that dental schools throughout the country use the California Dental Board's hybrid competency portfolio process. And if that would be the case, essentially you would perhaps be removing regional clinical examinations and just going out of dental school. Okay, that's for a future discussion. This is information now that's being discussed, and I think that it does merit a full discussion by the board at a future board meeting. In the meantime, we've got licensure by residency. We're talking about limiting how far back somebody can use the residency to apply for licensure in California. The reason why this is important is we have had people essentially who graduated from dental school 20 years ago and haven't been working clinically and want to come to California reaching back 20 years for their residency. And we can't guarantee public protection by allowing that pathway to licensure. So that's why we've asked for this change to our licensure by residency.
You know, Karen, I think an issue there that might be of value is the same as the issue with the Commission on Dental Accreditation's educational standards for dentistry. The Commission also has established and continues to modify the educational standards for AAGD and GPR residency programs. So if a dentist graduated from one of those programs more than 2 or 3 years ago, there's a different set of standards now that they are needing to comply with than they were previously. So going back any distance, significant distance, more than 2 to 3 years, is putting you into a set of standards that are not pertinent to today. So,
and I think that that's important information that as we start to review our different pathways to licensure, we'll be able to speak more to and bring in the changes that are being made. Right now, what we're requesting essentially is just the statute include a 2-year time frame in which somebody can go back to their residency. So I think that that would fall in line with what you're suggesting, that since residencies change, their standards and requirements change, we should be pretty safe with allowing somebody to go back at least 2 years. Similar with the next bullet, which is licensure by REB or ADEX or any regional examination. Those examinations are also periodically reviewed and updated in accordance with occupational analyses. And so the board would be asking the legislature to put a 5-year limit on how far back the candidate can use that exam for licensure in California.
Can I ask a question about the next bullet, replacing a license?
Please do.
I'm not sure that I understand what this says. I think what it says is that if a licensee someone was licensed in California, but then it was canceled for non-renewal, that they can only apply by paying back. Oh, I get that part. But then you say, even if the licensee could qualify by another pathway, such as licensure by credential, and then it ends with providing the opportunity to reapply for licensure through another licensure pathway, such as licensure by credential. I'm not sure what that says.
Well, that says essentially that if you've ever had a California license and you let it go, the only way you can do it is going through the new license to replace a canceled license. That essentially is almost discriminating against the person who ever had a license in California, because say they got a license in California and then went to another state and practiced for 20 years. What we're essentially saying is they can't come back to California to practice because they had a California license unless they pay all those back fees, which could be thousands of dollars, as opposed to if they came back meeting the requirements of licensure by credential, which is a substantially lower fee. So in essence, the way it's written, and I think this is one of those things that happens from time to time when a piece of legislation gets put into law, there needs to be more review of what's currently in law to make sure that something like this doesn't necessarily happen. Because one might say, the board is almost discriminating against somebody who's ever had a California license and penalizing them for leaving the state. I mean, if you're seeing it differently, now's the time to let me know. So if
this doesn't appear to me to be what this says.
Okay.
And that's why I was confused about this. What you said made more sense. And so I think, if I can repeat what I think you said, a person is licensed in California, they leave for a number of years, they want to come back and be relicensed. They could do that with licensure by credential.
Not now.
Not current law.
They would meet the requirements of licensure by credential likely, but they can't now. Because and we've said they can only apply for a new license to replace a canceled license by paying all the back fees. And we're asking the legislature to somehow tweak this so that it would allow those people that have left the state to utilize another pathway should they meet those requirements.
So Fran, if they hadn't been licensed, then they could have. I think that's what she was trying to explain.
Hang on just a minute, please. So then the option is what?
Their only option, if you've had a California license and left the state and let it expire, the only way right now you could come back to California is to receive a new license to replace a canceled license and pay all the back fees.
Okay.
That's the only way you can get your license back. And what we're suggesting is if you can qualify by another pathway, we would just need the statutory authority to let that happen.
Okay.
You still don't understand? I want to try to help you if anybody else can find an easier way to say this. Yvette?
Yes.
Ms. Chappelle? Ingram?
And I'm going to toss this hot potato to Dr. Lai, but before I do, this is a little confusing.
Okay.
It is a little confusing in terms of the language. And let me ask, we do have a licensure committee. I mean, is this a part of what it is that the licensure committee is doing as well? Because there's some other, it's not just paying back all the fees. It could very well be that they may have to take an ethics course, or they may have to take something else. And this isn't in here, and I think the flow of it is confusing. That last sentence can make it confusing.
That's what threw me off.
That's
it
the
was
only
like,
thing,
okay,
but I think
I was with you until then.
Right, but I think Dr. Lai can actually clear this up and give you the language. I know you're going to kill me.
I think what we're trying to do with that last sentence is for people that have practiced somewhere else, there's only one way to get your license back, by being reissued a new one. So if you look at, I mean, to me, it's pretty clear that if somebody, we don't want to penalize the people for coming back. And so right now there's two systems of what we're talking about under, if they can come back as licensed by credential rather than pay all the back fees, that would be beneficial to that person and to welcome them back to the state. So I don't know if that answers I don't think you look still kind of confused, but there's only, we're trying to make it easier and less costly for them to come back.
Now there may be
Right now
people
there's
that
two.
don't meet other requirements. So, I mean, if it makes more sense in that last line to say the opportunity to reapply for licensure in California through another licensure pathway, period, we can say that. I just used such as licensure by credential as an example. But if somehow you feel it's more clear to end the sentence at pathway, we can certainly do that. Now, this isn't to say that we're getting rid of new license to replace a canceled license. That's not going to go away. And there are still people who have essentially let their license go who would not meet a requirement for another pathway to licensure. And so hence you would have the requirement of taking an exam again or taking a law and ethics exam. Those would still go to the LCP committee for review when they apply through this new license to replace a canceled license. What we're talking about is that somebody who has kept up their clinical skills, who has kept up CE, who is able to essentially apply by another pathway to licensure. Right now, that would be licensure by credential, but because the other pathways wouldn't really qualify. So we could end the sentence after pathway if you feel it's clearer, but that's
helpful. That's helpful because when you repeated that, it was like, okay, so what are you saying? So I think if we ended that at pathway, it makes more sense. What do you think?
So, right, I think the credential, license by credential at the end confuses people. Say, oh, well,
okay.
I think if we didn't have that, it'd be better.
Dr. Lay?
Oh, okay. So I guess I have a question. So when you say opportunity to reapply for licensure, are you going to give them a different license number, or are they going to have the same license number that they had before?
Well, they don't. When they apply for a new license, no. Once your license is gone, it's gone. So you would get a new license
So would
number.
it make more sense to maybe rephrase this and not just say reapply, but to actually say the opportunity to apply for new licensure using the different pathways? You see what I'm saying? I think
Yes.
the word reapply
Okay.
is sort of confusing, to people. So if you say basically, they have the opportunity to apply for new licensure because they would get a new license number anyway.
Okay.
Okay.
And maybe that would help clear up some of the
Okay.
Also,
misunderstanding.
I think it's important that we understand that the current requirements for a licensure by credential does not only require that you have a license, a current license, and so forth and so on, but it also requires that you have completed the 50 units of continuing education that is required, even if the license that you currently have didn't require 50 hours of continuing ed. And it also includes the requirement to complete the required continuing education courses that California requires, even if the state that you currently have a license in did not require those. So that's saying you're applying to California for a license through the credentialing process. And part of that is that you have to submit documentation that you have completed the continuing education requirements for a California license, even though you didn't have a California license.
I'm not sure if that's true, because if they're applying for a new license, then that's different.
I'll read it
Now,
to
if
you.
we're talking about
Requirements for it.
giving them
Documentation
the
of 50
old license,
units of
then yes,
continuing
that would be
education.
included in the back fees and
No.
the delinquent fees.
I'm talking
and
about
all that.
licensure by credential.
Mm-hmm.
Okay, if you're applying for a licensure by credential, it is required that you have documentation of 50 units of continuing education completed within 2 years of the date of the application.
Okay.
The continuing education shall include the mandatory coursework prescribed by the board pursuant to subsection B of section 1645.
So yeah, but if you stop at pathway and not putting licensure by credential, that may also apply to the licensees who probably, let their license expire, but do not have the 5 years of experience. However, they probably did have AHED or whatever, within the preceding 4 years, then they could still apply.
Well,
You see what I'm saying? Because they may have gotten the initial license, but then they moved away, let that expire. I know that we're talking about I'm probably complicating the issue. But there are situations like that, that happens.
So any way they apply, they still have to meet our requirements.
Right, they still have, exactly.
So ending at pathway is fine.
Any pathway is fine,
because
exactly.
they're going to have to meet the requirements. It's not like
Right.
just because they apply,
Right.
they get a license. They have to
Exactly.
meet all the requirements no matter what.
Yes.
So it's basically taking away the penalty of the back payments, where if they had come straight from Iowa, they wouldn't have. But because they decided to move, thinking they were never coming back to California, and then they do decide, it is basically a penalty for someone who moved away, who had no way of canceling their license otherwise. You can't say, so it gets canceled for non-payment, but...
Can I add something there? So if a person's moving away and they're not going to practice in California, they should have went inactive then. If they did inactive or retired, they wouldn't incur that fee coming back in. So there is that where if they just threw up their hands and said, I'm out of here, well, that's on them. So that's why the penalty is there, I think.
I think we have consensus that it sounds like the board understands the issue. And so that paragraph will be adjusted to essentially remove the word reapply and just say the opportunity to apply for licensure in California through another licensure pathway period. Okay, thank you for that clarification. Okay, the next bullet is certification of proof of graduation for dental education. Right now, we require the dean, and sometimes that's problematic, and I think that it probably doesn't need to be the dean or a dean delegate. If we find out an inappropriate person has signed a form, we have the authority to do something about that. I don't anticipate that that's going to be a problem. So this is just kind of clean up language. The next issue or the next bullet is clarification of approved by the board. And I think that this is stated clearly, but correct me if I'm wrong. It's come to the staff's attention that sections of statute reference approved by the board. And there's no clear definition of what that means. For consistency, the board is requesting that language be included in the sunset review legislation that would add the phrase, or by the Commission on Dental Accreditation of the American Dental Association, wherever the phrase approved by the board appears. This essentially gives the board options. And for the board members who have for 10 years been saying, oh, well, it's CODA approved, so we're good, we never say that anywhere. So if you believe that if it's a CODA approved whatever, we need to include that in our statutes to be able to essentially justify what you believe to have been the case all this time.
Is this just limited to the situation we were talking about earlier with the approval of schools, or
it's not just limited to that necessarily, but it allows the board at its discretion to essentially accept CODA in lieu of their own approval. So while yes, this probably could be used for foreign dental schools, it's not replacing the board approval so much as it's adding to the board approval. Does that make sense?
It does. I guess as a blanket statement, though, I worry where if you literally just said approved by the board always means approved by the board or CODA, it could occur. I mean, I don't have that memorized, so it could impact places where you have no intention to impact.
And I agree with that.
Yeah.
I agree with what you're saying, but we haven't been able to locate one of those situations yet. Not to say that we've read every word of the Dental Practice Act. You have? I was going to say, wow.
I have identified one of concern to me.
Okay.
Okay. And it would be found in regulations, Code of Regulations 1025, extramural dental facilities.
But that's a regulation.
That's a reg. Okay.
So that's different.
Talking
We're
about different.
But go ahead, and why don't you finish your thought?
My concern is that it identifies that a extramural dental facility permit.
Do you have your mic on?
limited
Do you have your
to-
mic on? Your microphone? Oh.
is limited to dental schools that are approved by the board. So if the board approves all CODA schools, then would that not open up every CODA-approved school in the world, so to speak, to be eligible for extramural permits for their students to come to community clinics in California as part of their educational process?
Yes.
There's an unintended consequence that we need to be aware of.
If I may say so. Yeah, at the current time, there are many students that are coming from out of state, CODA-approved schools to do their externship rotations at community clinics and also dental schools. Many students that are interested in, say, oral surgery residency program, for example, they do some clerkships, at the dental schools where they would intend to apply. So that's going on right now. So it's not anything new. It's been going on for a long time. So I think that the board is trying to attempt to clarify that, I think is the right move, because we need to understand that CODA-approved schools in out-of-states are basically equivalent to the schools in California. We are accepting the candidates from those schools who pass the rep to come into California with no question. So why would we want to limit the dental students that are coming in here for their clerkship or for their, externship rotations?
I just respond to that by saying that this section continues on to identify what is meant by an extramural dental facility. And it is, as used in this article, includes any clinical facility employed by an approved dental school for instruction in dentistry which exists outside of or beyond the walls, boundaries, or precincts of the primary campus of the approved dental school in which dental services are rendered. I think an oral surgery internship, clerkship does not meet this requirements. That goes on, and I agree with you, that we have isolated situations where a student or a limited number of students will spend a period of time at a dental school in a clerkship, usually in a specialty area. These are usually fourth-year dental students who are wanting to get an understanding of what it's like to be in that specialty that is not employing the facility for educational purposes. So I don't think that the clerkships meet that requirement. That definition.
This is an issue, I think, that needs to be certainly discussed at a future board meeting, because it's come to my attention. I've heard anecdotal comments about this is going on, and I'm not sure that it should be going on. It may have been going on in the past. But to essentially, right now, for an extramural permit, the school needs to apply to us. I'm not really sure how an out-of-state school applies to the board and what authority the board has over an out-of-state school, or those students going to the school, I think this is an issue that we really need to discuss. That being said, it may be, and since we've had this discussion, that we should remove this from our sunset review just to research further whether there will be unintended consequences by essentially included or by the Commission on Dental Accreditation. Because if we vet another question at a future board meeting relating to extramural facilities or how this is all going to work, this could all be packaged in a piece of future legislation.
I guess I don't understand what you mean by unintended consequences. Maybe you can explain that to me.
So he has a specific example. I mean, I'm the one that brought it up, I guess, to begin with, because I don't know every place where approved by the board is used. And so if you now start saying approved by the board means approved by the board or CODA, you could come up with situations where we approve people for licensure. That's approved by the board. Well, what if CODA decides to do that, right? And now have you just said that they decide who can get licensed in California? I mean, I just don't know where the language is used. So it just made me concerned that I think conceptually we were talking about it in context of foreign dental schools, and maybe we all agree about that. And there could be dozens of other places we agree, but I was just concerned about a blanket statement that it's just going to be everywhere. Because here it also doesn't even just say in the Dental Practice Act. So I didn't know if that would also include regulations. I mean, does it mean it literally everywhere? And so that was my concern.
Well, I'd say that we need to get the statutory authority first before we would bring it into regulations, but that would follow. And I think the unintended consequences, I'll let Dr. Morrow refer to that, but he's brought up the specific requirement in regulations about extramural facilities. And staff will need to do the research on how that section of regs came into being in the first place. Was it intended to only apply to California dental schools? I would say likely it was, because that makes the most sense. But and I believe that it may be misinterpreted if you have schools outside of the state now sending students to clinics within California. So I think that that's an issue we probably can package together for a future board meeting. So unless there's a strong objection, and as a staff, Sarah, are you following this discussion? Okay. If I recommend that we just remove this from the report, can we find a different way to deal with what we need to deal with?
Before you remove it, you may want to vet it a little bit more, because there could be unintended consequences if you removed it.
Well, it doesn't exist right now.
Right. So I don't know if this is a wishy-washy compromise, but you could put that language and say where appropriate, and then that gives you the room next year to figure out where it is appropriate, but you've alerted them of the potential issue that it's coming, if that's what you're thinking about or you're trying to do.
Nobody knows necessarily if the legislature is going to take it up. Okay, so if we leave it in the report, we don't know whether the legislature is going to agree with us or disagree, and we would still have time to talk about it to clarify where we wanted to go. Is there something that you would want to insert now into this language, and then we would be bringing back, and because at some point through the process of sunset review, because we've said something in our report doesn't mean the board can't change its mind. If you get additional information between the time we submit this report and moving forward, of course that would be taken into consideration.
I have a suggestion that approved by the board including CODA for licensure purposes. And limit it to purposes for licensure that the education from a CODA-approved school would be considered board-approved, but limit it to licensure only.
Make one more recommendation, that we specify that this is for the practice of dentistry only. Board approved is CODA approved for the purpose of licensure as a dentist in the state of California.
Yes.
In the event that CODA moves more into dental assisting.
Well, the CODA does do dental assisting programs right now. There's, I think, a misconception that if you're a CODA-approved dental assisting program, then that means you're automatically accepted as a board-approved RDA program, and I want to make sure that that's
Could we specify it to dental licensure then?
Yes, that's what I think we need to do.
Okay, so I've made that note that we will revise this paragraph to limit this to licensure for dentists. And it's looking like people are agreeing with that. Okay? Okay, thank you for that discussion. Last but not least is our new issues raised by the committee, and this is our pediatric anesthesia on page 175. So essentially, AB 2235 required the board to provide a report on pediatric deaths related to general anesthesia in dentistry at the time of sunset review. We have essentially given a synopsis here, or actually it's not a synopsis, it's a detailed explanation of how this all came about and what the requirement is. Jerry, did you pass out the additional? So Jerry passed out a sheet that is unmarked. It's the top line says also requires the board. So essentially this is replacing page 177. And what it now includes essentially is where we had put insert the data here on page 177. The paragraphs, most of this page now includes that information. So I'm just going to read it to you. So everything remains the same in the first two lines and the next paragraph. Now this is new. The board has been collecting the data required in AB 2235 for 21 months. During this time frame, there have been 2 deaths reported for patients under 21 years of age. The first patient was 3 years old and underwent dental rehabilitation under general anesthesia at a surgery center. An oral surgeon and an RDA provided the service. During the procedure, patient experienced a life-threatening cardiac rhythm that required emergency medication and defibrillation. The emergency protocol performed was successful, and the patient was stabilized with a normal sinus rhythm. Patient experienced a relapse of life-threatening cardiac rhythms in the emergency room and passed away. Okay? The second patient was 16 years of age and presented for extractions. The procedure was performed in a dental office. All 4 wisdom teeth were removed. The patient entered the recovery phase breathing room air. During this process, the patient started to desaturate. Paramedics were notified, and the patient was transported and died later. So those are the 2 deaths. We defined 21 years and younger in the pediatric study that was done by the board. So that's why we reported that age group. Then we go on to say that during that same reporting period, there were 14 reported hospitalizations for patients aged 7 and below. Of these cases, 6 of the procedures were performed at a surgery center or hospital by a dentist performing the procedure, plus a dedicated anesthesia provider such as a certified registered nurse anesthetist, a dental anesthesiologist, or a physician anesthesiologist. The remaining 8 procedures were performed in dental offices, 2 of which reported that procedures were done by 2 dentists and a dentist and a physician anesthesiologist. In addition, for ages 8 to 21, there were 9 reported hospitalizations. Now, these hospitalizations did not result in death. In addition, for ages 8 to 21, there were 9 reported hospitalizations. A majority of cases were performed in a dental office. 2 of the cases were reported to have occurred in a surgery center with an additional provider present, such as a certified registered nurse anesthetist and an anesthesiologist. The board will continue to review the data as it is collected to determine whether certain data points are relevant and/or need further clarification. Is this adequate?
I have a few questions on this. First of all, you say you've been collecting data for 21 months. So when did that data collection period begin exactly?
January 1st of 2017.
Okay. And the reason I bring that up is there were 2 deaths in 16 that have escaped collection here. One of which we have filed an accusation on. The other, I don't know what became of it. But they were media reports. So there's a gap in there, which, I mean, if it's there, just say it's there. But again, there are a couple of cases out there.
But that was before the reporting period.
Right.
Correct. But I think that these things occur in clusters. And we have years with no deaths, and we have other years with several. So if you're going to be complete in your reporting, I mean, maybe just give the starting date and the end date of the report, and so they're aware there's a gap there. Because these were in the media, so it's going to come up.
Well, I mean, the and I understand what you're saying, but the legislation took effect January 1st of 2017.
Okay.
Okay, which we've mentioned in this prior description. So I can certainly put in essentially in the prior paragraph we say AB 2235 became effective January 1st of 2017. If you'd like me to define what the 21 months are, we can certainly say January 1st, 2017 to whenever we stopped collecting it, which may have been August. I don't recall if it was September this year.
Well, maybe just give the starting and ending date of your collection period.
Okay.
And that would suffice.
Okay. The reason we went into a lengthy description about the bill went into effect January 1st of 2017, and theoretically, licensees were required from that point on to notify the board of these certain data points. And we didn't have the courtesy form developed quite yet. So the accuracy of our data collected is questionable, which I believe is going to continue to be questionable. So, I mean, I hope nobody's looking at this data collection as necessarily a strong scientific display of what's really happening out there. But I can see that the Anesthesia Committee will be taking things to the Anesthesia Committee to start to develop perhaps policies on how best to interpret the information we're collecting, whether it's accurate. Already, just in the few reports that we're getting, it appears they don't quite have an accurate understanding of how they should be answering some of the questions. So while it's a courtesy form, I believe we still have the ability to try to help people through this. And I think that the Anesthesia Committee should be looking at the actual data points that are in statute and determining would there be some sort of a correlation, or does that somehow need to be revised? Again, not during this sunset review period, but in the future, how best to accomplish this. This was written in a way, Caleb's Law essentially came about, and the premise that I don't believe was necessarily supported with data was that if there'd been more than one provider in the room at the time, perhaps Caleb Sears would have survived. What we're showing in the data that we are collecting is that there incidents, death and hospitalization occur even under the safest conditions, I suppose, if that's how you would want to say it, where two providers are there, they're in a surgery center, which has to comply with a higher standard of equipment and operating procedures than are required for just a normal dental office, similarly with hospitals. So I think what our data is showing that tragically, deaths and hospitalizations occur in many situations.
Under the first case, the 3-year-old, who gave the anesthesia? That would have been in our form, I think, wouldn't it?
You know, and this is part of the problem. There are 3 questions that are asked that have to deal with who did the procedure, who monitored the anesthesia, who gave the anesthesia, and those aren't being completed. I'm not certain they're being completed accurately. So that is something that we're going to find a way to bring this raw data to the Dental Anesthesia Committee to take a look at. Purposely, we did not divide it by year because we really want this information to be anonymous, and we don't want people to be able to go back and track any media that may have occurred during a certain time and tying it to a specific case. So that's why there's somewhat of a vagueness in terms of how many years. But Dr. Richter is correct. There are years where nothing is reported, or certainly no deaths are reported. What I can say is that it appears that licensees are being diligent and are reporting things they probably don't need to be reporting. So we're also dealing with that. And it'll be a matter of just trying to educate the licensees of when they do need to report.
Ironically, I think the information that was available for our prior report was in some ways more complete. But
I think I agree with that.
yeah. So again, the problem with the data collection form is it was lifted out of a publication, and a lot more was done with collection of that data as part of that series of studies. They had a concerted provider education program. They had quality assurance on the data that was ongoing. They culled data out that was spurious. So just to set a form out there doesn't accomplish very much, and I think that's what we're seeing. Just a comment on the hospitalizations. We had a report of hospitalizations as part of our pediatric anesthesia study, and the pattern is very similar. What we find is younger kids are usually done in the surgery center, almost always with an anesthesiologist. The older age groups are more often treated in offices, and the numbers of hospital admissions are really similar across the board, whether it's oral conscious sedation or IV sedation or general anesthesia. The numbers are really pretty similar. So, again, this is just something that we've seen in the past, and there's just confirms it further.
Good question. Could you help me to understand what is the operational definition of a courtesy form?
It means that we can't require it until it goes into regulation, where we adopt by reference. So the board put together a courtesy form, which essentially is exactly out of statute what the data points are. I understand we can probably give a little more guidance, if you will, since it is a courtesy form. Now, licensees are not required to use a courtesy form, but they are required to submit the same data that's on the courtesy form, and they can do it in a letter should they choose to do so. So until the regulations are developed where this is actually put in regulation, that's why we call it a courtesy form. Okay, trying to be helpful along the way. Are there any questions? Okay, it's 2 o'clock. We're going to try to see if we can tie this up. Section 12 is going to be all of our reports and everything. That's going to be massive, so we did not include that. These are reports that are available on our website. If there's any particular report that a board member would like a copy of, just let me know. Send Sarah or I an email, and we can make sure you have a copy of the report. So in the final document, these reports will be there for legislative staff to review and the legislature to review. Our last section is diversion, and there weren't really no comments on the diversion section last time. I can just remind you that our diversion contract, or the department's diversion contract with the current vendor, will be expiring in December of 2019. So myself and the other 7 boards that do have active participation with the current vendor are in the process of putting together a new RFP to solicit bids for vendors to take over the diversion program. We will be having a diversion program on the November meeting. We've asked guest speakers to come in, and it was very well received when we did this a couple of years ago, so we'll be doing that again in November. Are there any questions? I'm going to hand this back to the president now to ask whether or not we can move forward with a vote.
Okay, procedurally, you're asking me to
ask for a motion to approve the board sunset review report and submit to the legislature by December 1st, 2018 with the inclusion of the additional comments that were made at the meeting today.
Thank you, Karen.
So move.
Second.
So we
moved by Dr. Morrow, seconded by
Morrow.
Is there any public comment?
Did you get that?
Mm-hmm.
Dr. Stewart, I think you're going to ask for public comment. Or not.
Is there any public comment?
There you go.
Thank you. Seeing none. Ready for a vote?
Okay, the vote. Burton.
Aye.
Burton, aye. Chan, absent. Chappelle Ingram, aye. Lai,
Yes.
Lai, yes. Laren,
Yes.
Laren, yes. Lay,
Aye.
Lay, aye. Mackenzie,
Yes.
Mackenzie, yes. You guys use the same one. Medina, Medina, absent. Morrow,
Yes.
Morrow, yes. Alagi,
Yes.
aren't you proud of me? Alagi, yes. Pacheco,
Yes.
Pacheco, yes. Stewart,
Yes.
Stewart, yes. Witcher,
Yes.
Witcher, yes. You,
Yes.
you, yes.
You yes.
It passes. Motion passes, Mr. President.
Thank you, board. This was awesome. I so appreciate that you took the time. I know this was a heavy lift for everybody with your busy schedules and everything, but it was very, very important for us to get this done. We will now make the appropriate changes that you recommended and send this off to publications for formatting and publishing, and we'll hope for the best during the process. So thank you all individually for your participation. This was huge. So
Yep.
thank you.
We wouldn't have done it. We wouldn't have done it except for you.
Thank you.
We had a team working on this. So I guess at this point, you can recess to closed session.
So moved. Closed session will now be starting.